let's start with Holy Public Domain Moses. So this actually starts from Jerry Fisher. Jerry Fisher is a photographer who went to scan this Moses statue. This Moses statue was created by Michelangelo. And this is a faithful reproduction of the Moses statue, and there's also the David statue on the other side. It was on public property. So what do you guys think? Is this infringement, or is it not infringement?
Infringement.
Why?
No, I'll change that. I'd say it's not because it was in the public domain to begin with, so it's not infringement.
Any other thoughts?
I would agree.
Yeah, no, I agree. You're right on point. Because the statue is public domain. Now, if we were to get into a situation where there was a extreme or some irregularity within the statue he was scanning that could be attributed to the artist, that could be one of those weird situations where a public domain statue gets taken out of the public domain.
Yeah, if the artist added something unique to it, but otherwise it's what? You know, it's several hundred years old, so I think it's out of copyright.
Yes. The artist is long dead by this point, so are all of the people who would benefit.
Did the artist add anything, you know, to it that would be out of the public domain? Right. In that case, the analysis would be different, but the facts, it looks like no, that didn't happen. Yeah, no, that didn't happen here from everything we've been told, but I think this case is a really important lesson because what Augustana College did, the moment they saw this pop up online, they sent a cease and desist letter, and it was probably one of the most confusing cease and desist letters I've ever read, since it mixed copyright law, property law, and trademark law, and municipal law all together in this really kind of incoherent mess of like, well, we're not exactly sure why, but we don't think that this is a good idea and you need to take it down. That is never the letter, especially for the young lawyers in the room, that is not the lawyer you should be sending. Or sorry, that's not the letter. It got posted, right?
It got posted publicly. The lawyers at the college, which, you know, it's tough when you're in-house counsel for a university, you're doing everything. So it's also one of those lessons of if something is outside your comfort zone and you're not sure, and you know you're in this realm of your letter will get posted to the internet and made fun of by legal blogs, those cease and desist letters are worth spending even more time with, since that's not something you really want future clients seeing on the internet. If your legal work is being mocked on the internet, that's probably not good for business.
What was their theory?
Their theory was that the artist, even though it was a faithful reproduction, the person who created this particular sculpture still had copyright, and regardless, somehow the copyright of the underlying statue had been transferred to the city. Now, what the city was doing with Michelangelo and a time machine is beyond me, but it was probably one of the least coherent letters I've read in a while, and that is saying something.
What was their trademark issue?
No, he was just doing the statue itself, and the statue hadn't been incorporated into the trademark. They were also really worried about him coming onto the property and getting injured, despite the fact that it was public property and he was absolutely free to be there. So those were kind of their theories. Not, you know, a great example. But our next example is the example that I came up with the title. So print me a song. So what creators are doing is taking MIDI files, turning them into G-code, and G-code is one of the coding languages that 3D printing CAD files can be done in, and they're printing songs. So, oh, yeah, sorry.
What is their X, Y, Z axis for that?
I don't remember, but just so you guys can have a listen. I think everyone's got the idea from there. So what do you guys think? Copyright infringement or non-infringement?
What is the tangible medium? I mean, where is it? We heard the song. But where's
the tangible, let's say the tangible medium is this video that they created.
Oh, this video right
This
here.
video. So they recorded this printer playing music and they put it up on YouTube. Would you have if Lucasfilms was your client, would you send a takedown notice?
I couldn't tell, I couldn't hear it well enough, so I couldn't, the original and the supposed copy, I couldn't hear it well enough, but if it's the same melody and the same rhythm and everything else, absolutely. Send them a cease and desist. That would be copyright infringement.
Any other thoughts?
But that, using that printer, would that be like adding like a transformative element to it?
Potentially. Now, you could make the argument that this is being done in a unique medium, that there isn't a strong licensing market for music files played on 3D printers and then put on YouTube. It's probably a very small
But
market.
those are excuses to excuse you from copying the melody and rhythm and all of the elements of the song, right?
Well, it depends on your view of fair use. Although many attorneys do believe that it is a defense and believe fair use is an excuse, that's not personally what I believe. That's not personally my reading on the law. My reading on the law is, yes, it is a defense, but if it is fair use, and there are many other statutes, especially a lot of the Digital Millennium Copyright Act kind of implies that if something is fair use, it is not infringing. So if it is not, if it's something is found to be fair use and it's not infringing, and I realize this is not a popular view to be held in a room of entertainment lawyers, but that's my view.
Well, we'll allow you to have that view, even if it's wrong.
Well, I'll allow you to have your view even if it is wrong.
Isn't it kind of just a technicality?
It really,
How you word it? I mean, the result's the same.
to a certain extent, yes. I mean, if something is found to be fair use, your client isn't going to get damages, and you might even have to pay attorney's fees. So if a case has a very strong fair use case, bringing the lawsuit anyways, maybe not the best plan, unless you're really looking to create case law and are hoping to create case law from the plaintiff's perspective, which I suppose could be a thing, but I don't think that would be in the benefit of anyone's client. So any other takes on this?
Well, what you played seemed to be music only. There were no words or a song.
Mm-hmm.
If there were words, then obviously they would be comparing to see if it were infringement of the song as well as the music. So that would make it more complex.
That could be true. In this case, this is the Imperial March from Star Wars, so there are no official lyrics, though some people have made some unofficial lyrics to the Imperial March. But I agree, in this, if they were able to replicate human speech, which I haven't seen anyone do yet with a 3D printer, that would be pretty impressive. But that could potentially lead it a little bit. It would definitely change the fair use analysis. It could play into the fair use analysis. I'm still inclined to believe that, because this video was created, but it's not creating any actual copy. The copy is incidental. But also because, this is taking a machine and doing something very unique. It's not a substitute for playing the Imperial March. No one is going to listen to this as opposed to the original score. The original score is just so deep and complex, and this is admittedly a very awesome 3D printer making some noises, but while reminiscent of the original song, it doesn't contain that depth, and there's no market for it.
But that's not really the question, is it whether it's good or not? It's whether it replicates the original song, and this wouldn't be an infringement of the performance of the song, it would be an infringement of the song itself.
So you could argue that. I don't know if it's actually hitting the notes accurately enough.
That's what I couldn't tell.
Yeah.
So that's hard to tell.
I mean, it's very mechanical, so I think it's hitting the melody in a
Sort of, yeah.
sort of, but it's not hitting the exact notes of the score because it's a little bit.
What is making the sound?
So what's making the sounds is it's actually the gears turning within the 3D
Inside
printer. Who isn't familiar with what's been going on with Left Shark? Okay, so Ferdinand, so during the Super Bowl, one of Katy Perry's backup dancers dressed in a shark costume essentially forgot all of the moves to his dance and kind of just started flailing around randomly. Minutes after this happened on live national television, he was christened Left Shark by the internet and became an overnight meme and overnight sensation. Ferdinando Sosa is a political artist. Now, he creates a lot of very controversial stuff, but he decided to create a Left Shark, and this was the original Left Shark design. Subsequently, in dealing with lawyers, he has created Lawyer Left Shark, which I'm a huge fan of. So he created this design. Very shortly thereafter, he got a cease and desist letter from Katy Perry's attorneys on both copyright and trademark grounds that Left Shark belonged to Katy Perry and that he needed to take it down. He was a law professor who I'm unfortunately blanking on the name of at this time, took up his case and has been in this very, very public dialogue with Katy Perry's law firm about why or why not Left Shark is infringing. And Left Shark really is actually a great teaching case at the moment because it presents a lot of very interesting copyright issues. Before we get into those, I do want to point out two interesting kind of practice points. One of the things that when a case becomes public, you really even have to start watching your step a little bit more. So when they went to register, when Katy Perry's lawyers went to register the initial trademark for Left Shark, they used this picture created by Ferdinando Sosa of the design that Ferdinando Sosa created. Not the best move. It's not something you should be doing anyways, but when you're getting a lot of press coverage for the cease and desist shoot, terrible idea. The other really interesting thing is that they sent a cease and desist, they didn't send a DMCA takedown notice. And there was a lot of talk, especially in the initial days, of whether this was because they weren't 100% willing to swear under penalty of perjury that they were actually infringing Katy Perry's rights. Now, there are some folks who say, a lawyer shouldn't be sending out a DMCA shouldn't be sending out a cease and desist letter that they can't stand behind. But, that's been an element that's become very public and very predominant. So it's another example of when you're sending cease and desist notices on these very public issues, being prepared for everything you write to show up on the internet, and being prepared to deal with the entire kind of copyright community geeking out over it on Twitter and all over the legal blogosphere. So one of the most interesting issues is the ownership issue. Does Katy Perry own Left Shark? So what do you guys think? Does Katy Perry own the Left Shark? And what's really at issue is the Left Shark costume.
You're talking about the copyright or?
We don't know the facts.
The copyright or trademark.
I can't say. I mean, did she create the costume? Did she draw it? Did she, sew it? Did she, there's too many facts that are missing.
Yes.
Was there a TM on the costume?
There was not a TM on the costume that I am aware of. Nor was it registered until nor was the first attempt to register it made till after that first cease and desist was sent. Some of the facts that have come out from Katy Perry's perspective is that she, not the NFL, owns the rights to it. The costume was, because she got the NFL to sign over the rights to the costume, this has not been otherwise verified.
After or before?
Before. That she owned the rights to everything related to her Super Bowl, her performance at the Super Bowl, not necessarily the other creators. Now, is it possible that that happened and that was in a contract? Entirely possible.
Had she gotten the rights from the original maker of the
Costume. Now, that's unclear. The only thing that Katy Perry's attorneys have verified at this point is that drawings were made before the costume was made, which is something that we kind of come to expect from most costumes. They have tried to rely and say that the costume, one of the arguments that's been made is that the costume is actually a derivative work of that original drawing, so even if the costume isn't copyrightable, because the drawing is copyrightable, they get copyright over the costume.
But who made the drawing, you know, what,
Yeah.
you know, there's just so many issues here, yes, and I'm sure Perry's attorneys have, you know, approached everybody and paid the money, so they really got an assignment of the drawing and the, whatever assignments they needed, I'm assuming, is that
Yeah.
the way the facts are showing?
The facts are
Nobody
unclear.
knows yet.
And that's one of the best parts of a hypo is sometimes asking, you know, what don't we know? What facts are missing here to make a determination?
For copyright under an audiovisual copyright like a film,
Mm-hmm.
which this would be recorded in,
Yeah.
the costumers are assumed to be part of that and done as a work for hire. And they don't get any separate copyright in that, as the same as the actors or, like, you know, the cinematographer or the musicians.
True. Provided there were
Well,
contracts. I guess I'm just referring to Garcia, but I think that case is going to be overturned.
Well, I just say in the sense of music for film is
Film.
included in the film.
Yeah.
Whereas if it's outside the film, then it's separate. This
Yeah.
was included in the performance.
Performance.
Yeah.
So you think it would be part of that performance?
Yeah. So I think she would, you know, if anybody owns it, she would own it.
Yeah.
But I don't think she necessarily owns that.
Yeah, and traditionally, costumes have not been included in that unless it's and I'm forgetting the term, but unless it's a really well-developed character, which Left Shark is definitely not a well-developed
No,
it
It looks like Land Shark from SNL.
It does.
It's very simple.
Yeah, and
There's also the whole character issues of, you know, is when does a character acquire copyright protection?
Mhm.
Right.
Or even more so, trademark protection.
Yeah, and that's what's really interesting in this case is, you know, Left Shark going into the performance, no real character. The character really only developed when a dancer forgot what to do on stage. And then the internet created Left Shark. So when you have an internet meme that's really created off of a live event and a character is developed around that, who owns the rights to the character that's developed by this crowd?
And it was publicly performed, it's not like
Yeah,
private screening or something.
absolutely. In one of the most public performances possible. So the ownership issue is incredibly interesting. All the facts have not been brought to light, so I don't think we can make a determination on ownership without knowing all of the facts. Separability is a little bit more interesting. Traditionally, and we've touched on this a little bit, costumes most of the time do not receive copyright protection because they're useful objects, much in the same way that fashion is. But if there are certain copyrightable elements that you can separate out, then that could be subject to copyright protection. Now, the best argument I've heard so far in favor of a separability argument is referencing a teddy bear case that I think was in the 10th Circuit, where the court found that a teddy bear was a sculpture, and therefore the teddy bear was subject to copyright protection. Though that argument doesn't really get to the separability argument, so I'm not crazy about that comparison. The last thing I wanted to touch on was fan art, and this is probably one of the most interesting areas right now in 3D printing. Fan art is continually interesting since there's a lot of fan art that is very transformative fair use, and there's some that isn't quite fair use and isn't quite transformative. And in the 3D printing space, a lot of the designs on Thingiverse, on Shapeways, on all of these sites are original fan work. So rights holders are in this really interesting quandary of how do we handle this? How do we handle the copyright enforcement of fan works, especially in this 3D printing space, which, you know, is really done by some of our strongest fans. So there have been a couple of ways of handling it. Now, some folks have been really strict about enforcing it. For example, Nintendo is always very, very strict about fan works, and a couple of years ago, they sent a takedown notice on this Bulbasaur Pokemon and a Pokemon vase. And Bulbasaur, for those of you who aren't familiar with Pokemon, is actually a little pocket monster that has a plant growing out of its back. So a very clever play on the character. Whether this is transformative or not, I think it's pretty creative. It definitely has a lot less detail. So it's a really cool work that was taken down. Some other folks, one other really prominent takedown of a fan work was the takedown of the iPhone holder / charger that is the throne from Game of Thrones. So they took it down. They tried to negotiate for a license afterwards. Didn't work. HBO has said, oh, we have a license for it. It's going to be produced by someone else. It's still never actually been produced at this point. And they refunded all of the money. So that's one way of handling it. And takedown notices are definitely appropriate in some cases, other folks are handling it differently. And now Hasbro, once again, has been really at the cutting edge of fan art. They have been working with Shapeways and superfanart.com to create super fan art. That is, they've gone out to some of their most popular fanworks creators and said, hey, instead of creating stuff and selling it on Etsy, why don't you do it through us? We'll get a cut, but you'll also get a cut, and no copyrights will be infringed since you'll have explicit permission. So that's been a very popular way of handling it, and the sales from everything I've read have actually been very good since they're getting even better quality products. The designs are amazing. Some downsides of this is they're obviously not granting for everything, so some of the designs that are maybe a little bit more critical or a little bit more subversive of the My Little Pony fandom, those aren't being accepted. Arguably, those are the ones that probably have the much better fair use arguments. So those are a couple of ways of handling fan works. No one's really figured out fan works from an economics perspective. Do you?
Parody?
Parody, yeah. Some fan works are parody, but not all.
But it applies just as well here, you know.
Oh, absolutely.
So those who are taking it to extremes or even doing obscene things would have a better chance at getting fair use than someone who just likes to do the same thing.
Absolutely. But it's definitely an entire spectrum with fan work. So some of the calls are probably a little bit easier than others. So what we've really been seeing is this movement slowly towards, like, as opposed to rote enforcement, how can we actually make some money off of this? And programs like Super Fan Art, programs in the non-3D printing space like Kindle Worlds, which is a fan fiction platform where creators can actually make money off of certain fan fiction within certain worlds on Amazon, and the original creator or copyright holder gets a cut. So that's an interesting model that's really started to develop, and I think it's a really nice hybrid for a way for the original creator to get some compensation, but for this fan community that's really some of the brand's strongest supporters to really flourish. Some folks have come forward and saying, you know, this is great, but in the cases of transformative fair use, they shouldn't be getting a cut at all. And I think that's, if you have a very strong fair use case, maybe these hybrid platforms are probably not the best place for those creators. If creators with strong fair use cases don't necessarily need to rely on these, the creators who really want to, you know, live within that world and do stuff that's a little bit less transformative and really is just about saying very boldly, I love this, I want to create stuff related to this. I think it's a nice hybrid where everybody makes money, and it's a nice way of handling it.